sacrifice in a world not of their making.
Good evening and welcome to the first in a series of programs on human rights, celebrating the 50th anniversary of the birth of the United Nations. My name is Stewart Rein and I'll be your host. In the course of our programs, we'll be discussing human rights issues in the abstract, the philosophical, but also in the practical sense, the world of real men and women and children. Perhaps the human race is not very human after all. Our history is littered with the corpses of men, women, and saddest of all, the children, who have been easy victims in a world where human rights are lost in subjugation to inhumane motives, power and aggrandizement. From simple, brutal individual crimes to organized state abuse, to the kind of systematic doctrines of destruction such as the Holocaust. Perhaps, as Freud suggested, there is a dark, brooding, morbid side to the nature of man. Or maybe we remain a primitive species, uncomfortable in our own social and psychic development. Forgive me if I seem to paint a portrait of mankind which is rather dismal, but even the most cursory review of human history demonstrates a continuous pattern of human rights abuses against individuals, religious sects, groups, genders, nations, and some whose social and political ideas alone pose enough of a threat to authority to cause the violation of their rights and perhaps often leads to their extinction. So to whom or where do we as common people turn to for protection and redress? Well, we look to the law. In the words of Thomas Paine, the 18th century American libertarian and scholar, every civil right grows out of a natural right, or in other words, is a right exchanged. The power produced from the aggregate of that class of natural rights cannot be applied to invade the natural rights which are retained in the individual, and in which the power to execute is as perfect as the right itself. In Paine's 18th century observations, we find the philosophical basis, perhaps, that sets the tone for our series. Natural rights or natural law is distinct from affirmative law of mankind. Those rules, regulations, and statutes which govern our social affairs as we go about setting up our modern nation states. Natural law and natural rights, as Paine stated, are inherent in the individual. They exist independent of affirmative law, and unfortunately quite often in opposition to it. So with this in mind, let me introduce our distinguished guests for this evening. On my left is Professor Neil Afrin, Assistant Professor of Law and Director of the International Human Rights Clinic at Touro Law, author of International Human Rights in the 21st Century. Neil is admitted to every court imaginable, so we needn't enumerate them, and has actively litigated human rights cases both here and abroad. On Neil's left, or your right, is the irredoubtable Martin Flaherty, Associate Professor of Law at Fordham Law, consultant to the Lawyers Committee for Human Rights, an international watchdog organization. Martin was former law clerk to Justice White on the United States Supreme Court, a former Fulbright scholar, and in addition to all of that, he's an expert on Northern Ireland. So, gentlemen, as I know of no subject that is spoken of so often and is understood so little, especially by me, let's start tonight with a definition if we can. Tell us precisely, what are human rights?
Well, Stuart, there are probably as many different definitions of human rights as there are humans, but let me try one. I would define human rights as ideas or concepts that aid an individual in preventing government from doing something to him or her, or in aiding or compelling government doing something for him or her. That would be, I think, at least a fair start.
Neil, I'm sure you're ready to jump in on that.
There is no absolute human right, and human rights would be relative to the needs of human beings to live in societies. However, that raises another issue. can different societies have different standards of human rights?
The relativist position. I think we'll probably deal with that at length either later today or on another of the series. Well, would you say, either one of you, that in a sense, in attempting to qualify, and I hope we'll also quantify a bit more particularly, human rights, are we really dealing with an attempt to redefine and codify common ethical, moral, and religious dogma, essentially, the sum of the world's knowledge about what is ethical, what is moral, what is right to do, and how to behave?
That might be one approach to it. Indeed, there is a legal doctrine called customary international law.
Right.
And without getting into the technical aspects of it, essentially the idea behind it is, what do governments abide by and what do societies abide by and value as human rights across the boards? So it reflects a consensus of what people value as the most fundamental aspects of human behavior. So in that sense, if you want to say that's derived from common ethical, religious norms such as that, then that might be a fair statement.
You wouldn't have an argument with that. What about you, Neil?
Well, I think we could look at every major ethical and religious movement and find a precursor for modern human rights norms and laws.
Exactly. Well, that's one thing I'd like to take a look at, because in attempting to define human rights, and I think we've made a beginning there, but I wonder, before I go to human rights origin, whether you could, for the audience, with a bit more particularity, describe what might be a typical human right, or a number of human rights. Due process. I'm thinking of due process, or freedom of information, or the right to practice your own religion. I mean,
well, some of the most fundamental that have been identified in international law have been rights against genocide, right against torture.
Right.
Then there are more elaborate rights of certain minimal due process rights in criminal trials. I'm sure Neil can enumerate several others.
Well, what we in the United States would consider basic civil rights, the right to free expression, the right to be allowed to associate with anyone. These things are also in various human rights treaties,
right.
And they are accepted in human rights as human rights law as well. So there isn't that much of a difference necessarily between what we know of, let's say, in the United States, and what are contained in human rights treaties.
All right, well, let's stop there for a moment and move back to the origin of human rights, because I know we've been discussing this earlier today, and it's a very interesting area. I've hypothesized that there's possibly a trail back to the 18th century, the Age of Enlightenment, and I know Neil has an alternate view of that. We could start with Neil and then go to Martin.
What appeared to start with the Age of the Enlightenment seems to have taken a 200-year, not a backwards turn, but a basically standing in place, and nothing really happened until a major cataclysmic event in the 20th century caused, I think, human society to reevaluate where we have gone and where we want to go, and to develop a new set of laws that apply to everyone.
Yeah, we'll come to that. We'll come back to that again. Martin, let's have a view from you on that.
Yep, there's a way I unite both your positions. I think it's clear that the Age of Enlightenment is the start of a modern conception of human rights. The problem is that conception was largely implemented within nation states. And during the course of the 18th and 19th century, there are really two sets or two approaches of human rights that flourish within nation states. One set might be called negative rights, right. The entitlement against government doing something to you, and then positive rights, which are more a Franco-continental phenomenon and ultimately a socialist phenomenon. An example of that would be a right to basic livelihood, a right to certain minimal social welfare rights. But again, as Neil said, it's really not until World War II that an international cataclysm forces the world community to care about what nations do to people within their own borders. whether it be a violation of positive or negative rights.
Would you either of you accept the proposition that power corrupts and absolute power corrupts absolutely? And I can't remember my source.
Lord Acton.
Was it Lord Acton?
I couldn't really agree with that 100%. I would say it rings true. Certainly absolute power, power not checked by the balancing forces within governments and within societies. But there seems to be, there's still power in nation-state systems, tremendous power. And we can even see that in, let's say, comparing the United States with European countries, the U.S. retains its power tremendously. So, whereas in European countries, they've relinquished so much of their sovereignty already.
Right. We're going to come on to that topic as well, I hope, when we have time. I think that having discussed the origin and driving ourselves backwards from the future into the past, and of course coming full circle back to the experience of World War II, let me pose another question to you. Frédéric Bastiat, the French philosopher and statesman, once wrote, "Life, faculties, production, in other words, individuality, liberty, property, this is man. And in spite of the cunning of artful political leaders, these three gifts from God precede all human legislation and are superior to it. Life, liberty, and property do not exist because men have made laws. On the contrary, it was the fact that life, liberty, and property existed beforehand that caused men to make laws in the first place." Now, would you agree or disagree? But we'll start with Martin.
I might agree with that as a philosophical proposition, but what I would hasten to point out is that position is not necessary to get to the modern position that Neil articulated, that human rights are in fact universal. One can say that human rights are universal because it is the law of nature that they be such. But in terms of the law, the reason human rights are deemed universal is either because there are treaties that have been universally ratified, or because of this conception of customary international law, which looks to the universal practice of nations and governments.
And I know that Neil had an objection possibly to God being the source of all of man's rights.
Well, it would seem that would be one philosophy to look to the origins of recognition of human rights as opposed to, let's say, the rights of animals. Since we look upon ourselves as...
That's what we are. Essentially,
that's right.
We're higher order of animals.
I sort of look at the situation as the law of nature as it applies to everyone, including animals and human beings, and that's where I would derive the rights of humans, let's say, as opposed to animals, and not the rights of the Almighty, which may not exist or may not be the same for everyone.
All right, let's hit on another topic. The question I asked in the introduction is where do people turn for assistance? Where do they turn? They turn to the law, is the answer I gave to that rhetorical question. And again, I want to quote my friend Bastiat, who says, "It is the collective organization of the individual right to lawful defense. Each of us has a natural right from God to defend his person, his liberty, and his property. These are the three basic requirements of life, and the preservation of any one of them is completely dependent upon the preservation of the other two. For what are our faculties but the extension of our individuality, and what is property but an extension of our faculties?" And he goes on, I'll try to be brief. "If every person has the right to defend, even by force, his person, his liberty, and his property, then it follows that a group of men have the right to organize and support a common force to protect these rights constantly. Thus the principle of collective right, its reason for existing, its lawfulness, is based on individual right, and the common force that protects this collective right cannot logically have any other purpose or any other mission than that for which it acts as a substitute." I think he's suggesting that law is force. I've heard this before, but never in these terms. Would either of you want to comment on? It's extended quotation.
Well, the law is often called, what makes the law is that government or some institution superior to government has a monopoly on force.
Right.
And thus, if there is that monopoly, you as an individual are going to have to use the rules that entity abides by to invoke force on your behalf, and that's the law.
Yeah.
I would agree, and I would say that modern conceptions of force as a method of implementing law has given way to a respect for the independent judiciary and independent courts, even ultra-national courts like the European Court of Human Rights,
Which we'll be discussing
which
soon.
don't necessarily need force today. The issue of force has been relegated, I believe, to a great extent. That's how far we've come.
Yeah, if I could jump in there, I very much agree with Neil on that point, because human rights doesn't just involve law in the sense of invoking institutions that have some notion of force. There's another kind of force, and that's moral force, or the force of world opinion and public opinion.
Right.
And one of the most successful groups or types of group that implement human rights are actually not government groups at all, but non-governmental organizations that use legal norms in effect to embarrass governments into doing the right thing.
You're thinking of Amnesty
I'm thinking of
International?
Amnesty International, Human Rights Watch, the Lawyers Committee for Human Rights, and various groups at law schools in this country that not only get involved with legal cases, as does Neil, but also get involved in going on missions to other countries and writing reports.
And I know you've done that. You've been to Northern Ireland. We're going to come to that in a moment. But it's interesting. I wasn't planning on discussing it today, but it strikes me. I know that you've done pro bono work, haven't you? I mean, would you explain what pro bono work is?
Well, it's work
area?
legal work that, let's say, law students and law professors and lawyers do to enforce, let's say, human rights law when no one else will do it. And for example, in the Soviet Union, the students and I went to the Soviet Union to argue for the rights of refuseniks and Soviet Jews and dissidents who could not leave and were being harassed and poorly treated in the late 80s. And by arguing for them, without any support from any government, we were able to impress upon the Soviet Union that this kind of behavior would not be tolerated, and that we would put pressure as much as we could bear to stop it. And indeed, that did, in effect, the combination of many different forces from non-governmental organizations and government sectors did, I believe, result in the end of the Soviet Union, in part.
Well, let's stop there, and I mean, we're going to come back because I want to discuss with Martin his experience in Northern Ireland. But I thought this might be a good point to begin discussing the United Nations Declaration on Human Rights, which we'd begun to discuss earlier, in a sense. In 1948, the United Nations acted, perhaps in the aftermath of the horrors of World War II, to create the first human rights document, from which I will quote, "Disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of the common people. It is essential," and I stress this, "if a man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law." Now, what impact has this document had on both our thinking and our practice? Which might lead us to Northern Ireland, I don't know.
I believe it's the most important document that has arisen in the last 50 years regarding human rights and an aspiration for the whole world, not just for this century, but for the next millennium. Whether we have implemented all of the provisions of the Universal Declaration of Human Rights, we are working on it, and it's happening, but it cannot be done so quickly that as national governments can pass laws.
But it seems to me, I'll give you a chance in a second, Martin, but I just wanted to interject the thought that when one looks at the Declaration and then compares it to the United States Constitution, there really are a great many similarities in terms of the protections afforded.
Not surprising, because Eleanor Roosevelt had a great deal to do with drawing up the Universal Declaration.
That's interesting. And one, before we move on, I wanted to get back to it only in terms of Article 29. We don't want to be pedantic here, but there is one caveat to the Declaration, it seems to me. It says that in the exercise of his rights and freedoms, everyone shall be subject only to such limitations as are determined by law, solely for the purpose of securing due recognition and respect for the rights and freedoms of others, and of meeting just requirements of morality, public order, and the general welfare in a democratic society. And it's with that in mind that I now return to Martin, because he has a great deal of experience in Northern Ireland, and I want to ask if there are any lessons in a human rights context to be learned from the Northern Irish experience, the British in Northern Ireland.
Yeah, I believe there are. Northern Ireland is a good example, I think, of what Neil was talking about. When I teach my human rights course at Fordham, I start off by telling my students there's good news and bad news. The bad news is there are human rights violations all over the world. The good news is we have a concept of human rights violations to begin with, which we didn't have 50 years ago. Now, with regard to Northern Ireland, for 60 years, that part of the island of Ireland has been governed by various types of emergency laws, which derogate from all sorts of due process standards. One example would be one can be taken off the street in Northern Ireland and put in incarceration for 7 days without being charged.
Right.
Now, that provision or provisions like it had lasted for a while. Since World War II, under a document that is kind of a child of the Universal Declaration, the European Convention on Human Rights.
Human rights, yes.
An individual in Northern Ireland could and has brought suit against the United Kingdom, stating that this system of 7-day incarceration violates the provisions of this international agreement, and has won.
Well, let me ask Neil then. Now that we know that there's a Commission for Human Rights in Europe and the European Court of Human Rights, what provisions have we here in the United States?
For taking an appeal to a higher court than the Supreme Court of the United States?
Or aside from?
Aside from.
Could you bring a claim independently in the United States for a violation of human rights law?
It's possible to conceive of bringing a claim for a violation of international human rights law if there is a treaty that the United States has ratified and implemented. However, there are only 2 treaties which the United States has ratified and implemented of the dozens of human rights treaties that the rest of the world has signed and ratified and implemented to a certain extent. The Refugee Convention and the Genocide Convention.
Why is that?
The U.S. has a view of itself, I believe, that seems to have a superior attitude to law, that we are the guardians and the creators of human and civil rights laws, and that we don't have to necessarily be involved with all of the other nations of the world. They have to meet our standard. I don't believe that's correct. I think that we have to jointly meet a one common standard. And I think we have that common standard, and it's up to the United States to fully meet its obligations.
Martin, quickly a response? Or?
Yeah, I agree. There's this idea in the United States that all we need to do is export human rights law, but I think we need to join with the rest of the world community and actually abide by the same standards that the rest of the world community agrees to abide by. That will make enforcing human rights in other countries more effective.
Right. Well, it strikes me that in the United States there's very little information about human rights. That's one of the reasons, one of the predicates of this series. Why is it that we are so poorly informed that human rights exist, what they are, how one incorporates them, and how one asserts them in this country? Are we in a sense fragmented from the rest of the globe? I would
think that the U.S. population thinks of itself as fairly well protected by its laws, and that it hasn't been a major issue in this country, except, I would say, regarding aliens' rights. And
well, I'll have to cut you off there, Neil. Unfortunately, I see we're running out of time, the great god of television. Tonight, we've just begun to scratch the surface of human rights issues. I hope that you will join us for the next programs, during which we are going to delve into the enigma of human rights, examining the interplay between the theoretical rights of individuals on the one hand and their application in our real, somewhat imperfect world on the other. We're going to focus on the problems of implementation of human rights laws both here in the United States and elsewhere, interpretation, conflicts with domestic courts and law. We'll be dealing with family rights, the rights of children, custody, access and petition to the courts, judicial accountability, freedom of information, and hopefully the future course of human rights law. Our thanks to Manhattan Cable for allocating a time slot for the series, to the United Nations Lawyers Committee for Human Rights, and to Children and Human Rights Council for their participation in the project. And a very special note of thanks to tonight's guests, Neil Afron and Martin Flaherty, for taking time out to appear. So let me leave you with a few last thoughts. One, as long as one man is enchained, no one is free. And every person, regardless of their station in life, rich or poor, is entitled to seek a remedy and redress for a wrong done. And finally, if that isn't enough, the old English common law adage that the king can do no wrong has surely been debunked by the king can and often does do wrong. So see you in 2 weeks' time. From the Human Rights Enigma, I'm Stewart Rein. Good night, Godspeed, and be ever watchful of your rights.